Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to offer you 6 tips for your hearing. And these basically are tips I would call those things that my clients said to me after hearings that they wish they had known before going into the hearing. And no particular order, but here they are. Number 1 is that when you talk to the judge, if you have to address the judge, you refer to the judge as Your Honor or Judge. Try to make it less, you don't want to be overly familiar with the judge. So if the judge says to you, if the judge asks a question you don't understand it, say, Your Honor, I don't think I understood the question, may I ask you to repeat it, as opposed to, I don't know what you said, what are you trying to ask me? You don't want to be too comfortable with the judge. Again, show the judge respect, show the judge that you recognize that he is an authority, and again, just the little things like that can make a difference, and the judge will like you, respect you more, and it could have dividends for you later on. If you're uncomfortable and need to stand up, you don't have to ask permission. So frequently, people with knee pain, back pain, whatever the case may be, need to stand up and move around a little bit. And that's especially the case if you testify. I can only sit for 20 minutes before I become so uncomfortable I have to move around, but you sit in the hearing for 45 minutes or an hour and don't move. And then later on, well, I didn't know if I was supposed to stand up. You can stand up. You don't have to ask permission. Just make sure you stay near the microphone so that the judge can hear your testimony. Number 3. It's okay to have notes. And what I mean by that is that there are times when you need to have notes at your hearing regarding your medications, maybe the pronunciation of your medication or the dates you worked in a particular place. It's okay to refer to those notes. Judges understand that you don't want to be reading from your notes. You don't want to be reading about your medical issues, but it's okay if you need to refer to, again, a date or a medication, something like that. If you need to explain to the judge, I don't remember things as well. I wanted to make sure I was accurate, and here's that information, and I wanted to make sure you had this properly, so this is why I'm referring to my notes. Number 4, there's probably going to be a vocational witness at your hearing, and the vocational witness is not there to talk to you. In other words, the vocational witness is there to answer hypothetical questions from the judge about what a hypothetical person could do given whatever limitations the judge comes up with. So if the judge asks a question with very mild limitations, assume, Mr. Vocational Witness, that we have a person who is the same age, education, work experience as the claimant, but this person can sit for up to an hour at a time, then needs to take a 5-minute break, then can resume sitting, and can stand for up to 2 hours at a time, and has a mild level of pain that causes a limited problem with attention and concentration. Could this person work in a particular type of job? Well, the answer to that question is going to be there are plenty of jobs that person can do. It is not appropriate for you to look at the vocational witness of the judge and say, that's not me. I have much more severe problems than that. You don't really need to be talking to the vocational witness at all. That's something for me to do as your attorney or the judge to do, but you don't need to be talking to the vocational witness, and this is not an open debate at that part of the hearing, and judges get very frustrated with people who interrupt them or engage with the vocational witness unless they're asked, because again, it makes things go slower, and the judge expects you to be prepared ahead of time about that. So only speak when spoken to, and always show respect to the judge, and again, realize this is not a conversation. You're being examined, of course, and your attorney's there to speak up for you, and your attorney will when that is necessary. Don't feel like when you testify that you have to basically tell the judge that you can't do anything at all but lie in your recliner and roll around in pain. I think people sometimes feel the need to tell the judge what they think the judge wants to hear. And that's really not the case. So judges recognize that you're going to go to the store, you may drive a little bit, you may walk the dog. Now you don't want to be doing something that looks like work, like cutting the grass on an ongoing basis or lifting heavy things, but basic activities of daily living, sometimes you can do those type of things. So you don't want to come across as someone who basically says, I can't do anything at all, I am completely disabled from everything and anything. Really, remember, the standard is, do you have the capacity to work a simple entry-level job? It's not, are you bedridden 24 hours a day? So again, tell the judge the truth. They can tell when you're misleading them, you're not telling the truth. Tell the judge the truth, that your capacity is pretty limited. You wouldn't be reliable at work, but you can do some basic things. And the 6th point I would make is that realize in a disability case, you are not entitled to disability. They call it an entitlement. Really, it's not an entitlement at all. because we have to prove that you meet the standard for disability. This is not something you get automatically. And if you walk into court with the idea that I'm disabled, judge, you need to pay me, and I know I'm disabled and I can't do anything at all, judges pick up on that attitude of entitlement, and it can hurt you. It's much better to go in with the idea that I hate the idea of being disabled. If I could go back to work, I would. This has been frustrating for me, both physically as well as emotionally. I don't want to be here, but I'm here because I have to, and if I get better, I'm going to be back to work for a multitude of reasons. Judges pick up on that. So you want to show the judge that you are here not because you want to be, but because you have to be here. And really, these are things that, again, at the hearing, it's very subtle sometimes, but if you let the judge know that you're here only because you have to, and it would be temporary if it's up to you, that can go a long way at really establishing you as a credible, believable witness, and it makes your case that much stronger. So those are six ideas that I would ask you to keep in mind as you go to your hearing, and you'll find, I think, that it makes your life easier, makes the judge's life easier, and certainly your attorney's life easier, and I think it will improve your chances of getting a favorable decision, which I certainly wish for you. So again, this is Jonathan Ginsberg. If you have any questions about this or anything with Social Security, let me know. If you liked this video and found it helpful, please like it on YouTube, like it on Facebook, give it a thumbs up, subscribe to my YouTube channel, and let me know if there's any other videos you have any thoughts about or anything else I can record for you. Or any questions you may have, I'll try to answer them for you. Again, Jonathan Ginsberg here, and I'll talk to you soon.